So when I finally became a licensed attorney in the US, I made a decision that still guides my work till today. I told myself I would dedicate my career to breaking the two biggest enemies immigrants face, which is fear and ignorance. Why? Because I have lived both. Today, I help immigrants understand something many still do not know. America is not your enemy. Yes. America simply requires you to follow the legal process, even under Trump. After representing immigrants for over 29 years and helping more than 12,000 get their papers and file their immigration case, I know this truth about America despite the drama going on today. No country on earth offers more legal pathways for immigrants than the United States. You just need to understand the options and have the right legal guidance. So my mission now is simple: to help immigrants stop living in fear, to help them discover opportunities they never knew existed, and to guide them toward the future that they deserve. So if you feel lost in the immigration system, if you believe you may have options but don't know where to start, or if fear has been keeping you from pursuing your legal status, you don't have to face it alone anymore. My name is Attorney Ope Banwo, and that is why I fight for immigrants. Speak with me today. Myself and my 30 staff of lawyers and paralegals stand ready to fight for you. Okay, welcome to another exciting edition of Immigrant Survivor Show with Dr. Ope Banwo for today, Monday, 20th of July, 2026. We are back. We've been off for a couple of weeks, taking care of business, and now we are back. Well, with me, as usual, is my co-presenters, Grace Okafor, one of my research assistants right here. Grace, how are you doing today?
I'm great, sir. Thank you for having me.
Okay, cool. And
then,
of course, Samuel Upon, my Ogapatagata, in making this show happen. Thank you so much for all you do, guys. I appreciate you, man. What say you, man?
Thank you very much, sir. You're all welcome to the show.
Awesome. Today, we are going to be having a lot of fun answering your questions. You know the way it is. First, I'm going to start with what I call now immigration advice of the day. I'm not going to make it too detailed so that we don't take all the time in talking about the rant. And then we're going to give you immigration updates of the day. What are some of the updates that is happening right now? Okay, in the last few days. You know that every day you wake up in America today, something is always happening. Donald Trump is always up to something, or USCIS is up to something. So we're going to be sharing with you a few updates that have happened in the last few days since we last came on. And then, of course, I'm going to be giving you, I'm going to be answering all your questions posted to our groups, to our pages, some today, some last week. And Samuel and Grace are going to be helping me to do all of that. So today, as we get started, I would like to start with what I call the advice of the day. And this is going to be about the immigration document that could save your future, but that most people do not have, or the immigration question that keeps lawyers awake at night. And for many, you might be thinking, oh, is this, is that, but it's so simple. Is your immigration file. Yeah. Your immigration file, your complete immigration file. Many immigrants keep their passports, their visa, their green card, they keep it safe, but they overlook the most important record that they will ever need: their complete immigration file. See, this file, when you go to a lawyer, maybe you're already arrested or you have some major emergencies, and then the lawyers don't know what you already have with immigration. Because when you file something that contradicts what you already have there, that creates more problem for you than solutions. So it's one of the questions I dread the most, or maybe I want to call it the immigration document, because it is a document. Maybe that's what we want to call it, the immigration document that could save your future, but most people do not have it. And we are talking about immigrants to America, immigrants in America. Every one of us who are immigrants, we keep our passports, our visas, our green cards. We keep them safe, but we overlook one of the most important records that we will ever need, which is your complete immigration file. This file can become critical when applying for immigration benefits or when you are responding to government requests. It can help reveal your immigration history, identify errors in your case, support your case. Many immigrants don't even realize they should review their immigration records until it is too late. I have an experience with this just last week. Somebody was arrested and they needed me to step in and help solve the problem. And I was asking, what are the things he has with immigration? The mother was telling me, I think he did something like this 4 years ago. He filed something else 7 years ago. But they don't have copies of the file. Oh, we filed asylum, but they don't have a copy of it. And you are supposed to be defending them now, responding to issues now. Many don't realize that. They didn't realize that they need to review their records. And many don't have any files, though they have had several encounters with immigration. I'm talking about documents like a simple copy of your I-94. Many who are watching this right now probably don't have one, because they don't give you one at the point of entry anymore. And you must go to the website of immigration, the CBP website, to download one. So some people come into the country, they just assume they'll be given 6 months, or they assume they'll be given 1 month, or they might even be told at the point of entry will give you 30 days, but they don't give you any document. They don't stamp it on your passport anymore. You have to go to the CBP website to go and download a copy. And many don't even know where to go. So they don't download anything. They don't even know what the time they're supposed to leave the country. And they keep looking at the expiration date on their visa, which does not count once you have entered the US. The expiration date on your visa is not what determines your stay in America anymore. It is your I-94, the number of days they gave you on that document, which should be in your file, which you should download. I'm just talking about, that's an example. Some people will tell you, they come into my office, like I had one last week, or he said, oh, I've been referred to immigration court. And he came into my office with a copy of the letter to report for deportation case from immigration. He was all panicked. I'm like, okay, no problem. How did you get it? I said, oh, I filed for asylum, and then they denied it. Now they've sent me to immigration judge. I said, no problem. You can always refile your application before the judge and do it better now, since you did the other one by yourself. Or he said, no, he did it with a lawyer. I said, that's even better. Where is a copy of it? Because you are not going to use that application you filed with immigration before the judge. You have to file a new one, updated one with better documentation. The man told me he doesn't have one. That I had it 5 years ago. I've lost it when I was moving house. I'm like, we can't go and file a new asylum application without knowing what to put in the old one, because then we can contradict each other. Then immigration is going to come and tell the judge you are lying under oath, because the other one you signed it under oath before them. So if you go file another one and you are contradicting yourself, of course, your new one is supposed to build on the old one, present it better, more focus on what will get the judge to grant you the asylum, cover a lot of stuff that you probably didn't cover in your own self-filed asylum. I get that, because that's the job of lawyers. But whatever the new lawyer is filing cannot contradict what you have filed yourself or what the old lawyer filed. It still has to be generally based on that. Many don't have that record. That's just another example. A lot of people, they file their papers with notarios. Those that they call notarios, people who can help you complete immigration documents, but they don't have copies of it. So sometimes they listed children in one, or they listed the brothers and sisters they listed. The date of birth is different from what they want to put now, and that can cause so many problems. In case you don't get it, here are some some good reasons why having your immigration records in a file matters a lot, no matter how small it is. It helps to verify your immigration history when that time comes, because once you are arrested or you are referred to judge and your case gets very critical, you need something that we can use to verify your immigration history. Your immigration file can help you uncover errors, missing information before you file a new application. Today, I was filing an application for a client, and because he had his own immigration file, when I sent him documents to sign so that we can file, he quickly got back to me that, no, you spelled my middle name wrong, and you spelled this one wrong, you spelled that one wrong, because this is what I have that I've sent to them before. That documents you have may be different. See, if he didn't have his own copies of what was filed before, that would have gone in and that would have created more problems for him than solutions. That's why you need one. It provides important records if your original documents are lost. Because when you lose your documents and you want to apply for a new one, you have to put it's better to have a copy of the old one that you can give them to get another original, maybe your work permit or whatever. If you lose it, you need a copy of it to be able to get a new one. There's some information on it that we're going to need to be able to apply for a new one for you. Your immigration record helps your attorney prepare a stronger case without contradicting your past story. A lot of us file stuff ourselves because we don't want to pay lawyers or we don't have money to pay lawyers, and which is okay. Some people get approved on their own. I'm not going to stay here and tell you cannot file your immigration yourself. You can do that. A lot of people do it, even though I think it would be stupid to do that these days, to file anything with immigration without a lawyer. But the fact is, you can do it if you want. But without that copy, any other thing that is filed for you in the future may contradict. It will not allow us to prepare a very strong case for you without contradicting your past story. Another reason is that why you need your immigration file is that it can reduce delays caused by missing or inconsistent information. If you don't have if we put inconsistent information in your new package, it can cause a delay, it can cause a denial, it can even cause bigger problems. They call it misrepresentation or misrepresentation to immigration. They can even call you out for immigration fraud. That's what they mean. That's when they say immigration fraud. It doesn't mean you have committed fraud in the traditional sense. It means that what you are stating is different from what you have stated before, or the reason you are giving now is very different from the reason why you came, stuff like that. And also having your file will help to explain past immigration decisions or applications in case situation changes. In today's immigration system, accuracy and proper documentation matter more than ever. The immigrants who are best prepared are often those who keep complete records, who review their immigration history, and who address potential issues before submitting new applications. Your future may depend not only on the application you file today, but also on the records that tell your immigration story. So my number one advice of the day or of the week is try to get your immigration file together. If you are here already, for instance, every interaction you have ever had with immigration, you need to get a copy of it. You need to have a file of it ready in case of emergency. Because when you are in jail, it is difficult for anybody to be searching and finding anything. You can tell them where to go get it in your house. If you are not in jail and you are filing an updated thing or you are doing something else with your lawyer, if he doesn't have the correct information and he puts in something that contradicts something as simple as your previous address. If they ask for the address that you have lived in, you put in one address and it's different from what is in the other file that you have before, that can create major problems for you in today's immigration. So that's my advice for you as my opening today. Make sure you get your copies of all your immigration files. If you don't have one and you have lost them, you can still right now do what they call freedom of information. You can request for a copy of your file, get to a lawyer or go to the immigration website and get the link for you to be able to fill the form, pay the little money for you to be able to get copies of your file. You need to have it so that when you walk into an immigration lawyer's office, you have something to give him to work with. Then he can review everything, and based on that, we'll be able to come up with a good strategy for you. Hopefully, that will bless somebody today. Hopefully, somebody will start taking this thing serious. You start getting yourself together, because right now, most immigrants, we're at war right now. The goal of America is to reduce immigrants in this country. You know that, you are seeing it. They tell us, oh, it's only immigrants with criminal record that they are deporting. But what we are seeing every day is not that. Even guys who have never had any criminal record, when they get careless with their status or get careless with themselves and they come before immigration, the next thing you know, they are deporting them. Having your immigration file ready is one of the most important services you can do for yourself right now, because you don't want contradiction in your story when it comes to crunch time. That is my opening advice for today. And of course, not like I told you guys before we go into the updates. I know I'm going to be sharing the immigration updates with you. And there are 3 powerful ones that I've developed just in the last couple of days that I think is very important for every one of you watching this to be able to know, because it affects you, it affects me. And ignorance of the law or of the rule is no excuse with immigration now. But before we come to that, I want to show you another episode of the series that my law firm recently sponsored. You know, because most times in America, they tell us immigrants just come to take away from us. Immigrants are just taking opportunities they are not giving. So we did a series. It's called the Immigrants Wall of Fame, where we try to celebrate some of the more consequential immigrants who have come to this country and who helped to build America, even from way back, who contributed more than they took from America, who are legitimately people we can say they helped to build America as it is today. We have, I think, 12 or 13 episodes of that. And today I want to share with you, and today I'm really excited because the one I'm going to share with you is a man that many don't even know about and who happens to be a Nigerian. I'm so proud of him, right? Because he's a man that some even credit with being one of the ones who started the internet, believe it or not. His name is Philip Emeagwali. I'm going to play a short documentary for you, and when we come back, we will take the updates of the day. Enjoy. I'll be right back.
Philip Emeagwali, the Nigerian immigrant who helped push computing into the future. Eastern Nigeria, 1968. The Nigerian Civil War had turned ordinary families into refugees, schools into ruins, and childhood into survival. But somewhere inside that chaos, a young Nigerian boy named Philip Emeagwali was falling in love with numbers. One day, that same boy from war-torn Nigeria would help push modern supercomputing into the future and force the world to rethink where genius can come from. Philip Emeagwali was born in Akure, Nigeria, in 1954, but much of his childhood unfolded during one of the darkest chapters in Nigerian history. When the Biafran War erupted in 1967, millions of lives were shattered. Food became scarce. Bombings became normal. Schools shut down across parts of the region. His father, a nurse, educator, and disciplinarian, refused to let war destroy his son's future. So while many children were consumed by survival, Philip was being pushed toward education. Without formal classrooms, he taught himself mathematics from old textbooks and independent study. In the middle of instability and uncertainty, numbers became his escape route. While war tried to shrink his world, his imagination kept expanding beyond Nigeria's borders. Years later, Philip Emeagwali arrived in the United States carrying little more than ambition, discipline, and a mind hungry for knowledge. He studied at Oregon State University, then continued advanced studies at George Washington University and the University of Maryland. But America was not easy. The pressure was relentless. As a black African immigrant entering elite scientific spaces in the 1970s and 1980s, he often had to prove himself twice. There was loneliness, financial sacrifice, academic exhaustion, and the quiet burden immigrants know too well, the fear of failure when your entire future depends on success. But immigrant dreamers are powered by something different. They know opportunity is precious because they have lived without it. At a time when scientists were trying to solve increasingly massive computational problems, Philip Emeagwali became fascinated with a radical idea. What if thousands of processors could work together at the same time, instead of one computer solving problems alone? This approach became known as massively parallel computing. Working with the connection machine supercomputer, Emeagwali developed methods for using thousands of processors simultaneously to perform complex calculations at extraordinary speeds. His work helped advance high-performance computing, the same computational concepts that influence modern scientific simulations, weather forecasting, oil exploration, engineering systems, and large-scale data processing today. In 1989, he received the prestigious Gordon Bell Prize, often called the Nobel Prize of Supercomputing. Think about that. A child who once survived wartime hardship in Nigeria helped humanity move deeper into the digital age. America's greatest strength has never only been its wealth. It has been its ability to attract dreamers. Immigrants like Philip Emeagwali brought intelligence, resilience, and relentless hunger for opportunity. And America benefited from it. Today, powerful computing systems help universities make discoveries, help doctors save lives, help engineers solve impossible problems, and help industries power the modern economy. Behind many of those advancements are immigrant minds, minds willing to sacrifice everything for a chance to contribute. Philip Emeagwali's story is bigger than technology. It is the story of possibility. A boy who survived hardship in Nigeria helped push computing into the future. And somewhere tonight, another immigrant child is arriving in America carrying invisible genius inside them. The next scientist, the next inventor, the next mind capable of changing civilization itself. Because brilliance can emerge from any village, any country, any continent. This tribute to immigrant greatness is brought to you by the American Immigrant Support and Empowerment Network, AISEN, and sponsored by Banwo Law and Associates, helping immigrants achieve the American dream without the nightmares.
Oh yeah, I hope you enjoy that. We are very proud of Philip Emeagwali, not just because he's one of those accomplished immigrants who helped to build America, but because he's also from my country of birth. We have this Hall of Fame going on. Out of the 20 that we selected, I'm so proud to say about 3 of them are from my country of birth. We have people from all over the world who came and who helped to build this nation, from Europe, from Russia, everywhere. And we're going to be spotlighting them every once in a while on this show as our own way of recognizing and celebrating those among us who did a great job in building this country. All right, now we go to the updates of the day. Because I know many of you, that's what you are really interested in. Let's get straight to it. Let's talk about the updates, because every time you wake up in America today, there is always one story, one new development affecting immigrants. And these last 3 or 4 days have not been an exception. It has been how this has been going down since our man came into power. Here we go. Immigration update number 1 for today on this show on July 20 is the Trump administration has now moved to limit student exchange visitors and foreign media visas. So if you're an F1, you're an exchange visitor, J1, or a foreign media, you may want to, somebody on foreign media visa, that's the I visa, you may want to pay attention to this update. The Department of Homeland Security has issued new regulations that will significantly change how long non-immigrant visa holders can remain in the U.S. Under this new rule, most people who are in F1 status, yes, most who are in F1, most who are in J1 exchange visitors, who have J1 exchange visitor visas, will be limited to a maximum period of 4 years, instead of allowing the individuals to remain in what is called duration of status while completing their program. Before, when you come in as an F1 or J1 or even I visa holder, they give you what is called DS. That's duration of status. They are changing that now. So for those who have I visas, those are the journalists, foreign journalists. Now they are going to limit you to maximum 240 days. That's 9 months or so. 240 days for you to be here or to be gone. While those from China was an exception. They will only receive visas now for 90 days. No more DS. Number 2, graduate students will no longer be allowed to change their educational objectives or to transfer to another school without prior authorization. Before, you can change school and just file a new documentation to show that you are now in a new school. But they're saying now with the new rule, you will now have to get authorization to change schools before you change it. Number 3, under this update, the grace period after you have completed your studies or your authorized training, if you're in the J1 category, will be reduced to 60 days. Will be reduced from 60 days to just 30 days now, which is now giving graduates less time to secure employment, less time to change their status, and less time to make arrangements to leave the U.S. Before, when you finish your course, when you graduate in F1 or you finish your J1, you are going to get 60 days extension to either try to plan to go back or to figure out what to change your status to still remain here. They are changing 60 days to 30 days now. So these new regulations are scheduled to take effect 60 days after publication in the Federal Register, and it was published just a few days ago. So that means you see about 45 days or so for it to take effect, subject, of course, to congressional review. Congress can still decide that they want to limit it or whatever. But right now, the clock is ticking because it has been published. Now you have less than 60 days to get that. Why does this matter? If you haven't figured this out, I'd like to explain this part, because some people will hear this update, they don't understand why it matters to them. To me, this development represents one of the most significant changes to student and exchange visitor immigration rules in many years. Because for decades, many international students remained in the U.S. under what is called DS, duration of status, which allowed them to stay as long as they continued complying with the educational program. So many of them can even be in this DS status for 7 years, 8 years, as long as they just keep remaining as a student. They keep doing, keep registering for new courses. That's why you see some people, they are perpetual students in America, not because they love to read, but because that is how they are able to keep their status because the F1 is DS, duration of status. For as long as you're a student, you can carry it. They've changed that now. So the proposed changes will impose fixed admission records or fixed admission periods, and it will significantly tighten your post-graduation timelines once it takes effect. So for international students, if you still haven't smelled the coffee yet, this means less flexibility in managing your academic programs, less time after graduation to secure your H-1B or another lawful immigration status, increased administrative requirements for those who are needing additional time to complete their studies. It puts greater pressure on you and your family and everyone around you to carefully plan every stage of your immigration journey. Universities, employers, exchange programs may also face increased administrative burdens and compliance responsibilities because now they are requiring them to file routine reports on this issue. Of course, what is the Rottweiler's advice? Because you are going to be asking me, Immigration Rottweiler, what is your strategic advice for this? Here is the Rottweiler strategic recommendation that I can give you. I would say if you're an international student, you should begin planning your immigration strategy long before you graduate, not after you get your diploma or the month you are going to get your diploma, as many of you are doing right now. The game has changed. You need to start planning the next step if you really want to stay in America long before that time expires. Maybe by the time you have 2 years to go, you have started planning. Number two, my Rottweiler advice for you, do not assume you will always have 60 days to decide your next move. Under this proposed rule, yes, not yet in effect, but it's coming, you may have only 30 days. Number three, advice here. Students who are considering transferring schools or changing academic programs should seek guidance before making any changes. This is very important. Don't just do this on your own anymore. My number four advice here, employers who are intending to hire graduates should begin sponsorship planning. You want to start that earlier to avoid unnecessary delays because things are not as fast as they used to be anymore. And finally, if you are studying in the US and you hope to remain here permanently, like most of you, I know that those who just came to study are going to go back, but many students who are here, we know that's just the reality. They want to stay here permanently. I would say start evaluating your long-term immigration options, such as employment-based green cards, family-based immigration, or other available pathways well before your program ends. There are many other options out there for the employment-based people. You want to start exploring them now, whether it's EB1, EB2, EB3, whatever. You want to talk to lawyers, you want to know what the options are. If the one that you are going to be applying for needs labor certification, you better start early, so that by the time you are finished, it becomes a good transition for you. Because the bottom line here, whether we want to recognize it or not, the bottom line is the Trump administration is signaling a broader shift towards tighter oversight on legal immigration. Whether they tell you it's only illegal aliens they are interested in, don't listen to them. For international students and exchange students, success will increasingly depend on careful planning, strict compliance, and early legal strategy. Book a consultation call to talk about these things now. Some of these consultation calls, like if you book a call with me, it's only $100 for us to go on Zoom for 1 hour, for us to look at your options for you and give you strategic advice. Some lawyers might charge $200, some charge $250, but I'm saying whatever they charge is worth it. Pay the money, get proper advice, because that $100, $200, $250 you're going to spend will save you thousands of dollars down the road. As I always tell my clients, and I tell them all the time, whether you come on the call or you are my current client, in today's immigration environment, waiting until the last minute is no longer a strategy. It's a risk. It's a big risk, because once castle has burst, once problem has started, it will cost you a lot more than it will cost you to try to fix it before there is an emergency. Because we lawyers, we love emergency. Can you blame us? When you go on an emergency, then you're going to pay emergency money. But when you go on a $100 consultation and they give you great advice, you know what to do. At that point, you can decide whether you want to hire the lawyer to do the work or even want to do it yourself. Especially those of you in J1, F1, you are very intelligent, you went to school. Once you know what to do, you can make efforts either to even start saving money to pay for lawyer or to go do it by yourself or whatever. But once you are already out, once problem has started, to even see lawyer at that time, you are talking thousands just to see and talk to him, not $100. So that'll be my advice for you. It's teaching time, saves 9. In my local language, we have a saying that is loosely translated that a war that is announced in advance does not catch a cripple unawares, meaning that before the war reaches the town, the cripple will have been moving fast, will have been moving months, weeks before the law gets into town. You can't start running when the law is in your when the war is in your compound, when you can't run, when you know you're a cripple. So as an immigrant in F1, J1, or any of the status affected by this new update, you want to look for solutions before you need it. Immigration update number 2 for today. Yes, you have been hearing about them, but now they are getting into the game too. The CBP, the Customs and Border Patrol, okay, they are expanding their biometric exit controls now. So leaving America is now part of your immigration screening. Before, America only cares about when you are coming in. For those of you who have been here before, when you are leaving, nobody cares about your fingerprint, nobody cares about your record. You just board a plane and you go. Even then, when they were even still giving us I-94, most people don't submit it. They just go and they get away with it when they're coming back. That is changing now, and you need to pay attention to that. Nobody's going to listen to you. I just left the country, I didn't know. Here is what CBP is doing now. U.S. Customs and Border Protection, that's CBP, Customs and Border Protection, is expanding biometric exit controls across airports, seaports, land borders, and other departure points. In case my English is not clear, in plain English, this means that many non-U.S. citizens, that's many of us, I'm a citizen now, but I was once like many of you out there, many non-U.S. citizens may now be photographed or biometrically screened when leaving the U.S., not only when they are entering. The CBP system generally uses facial recognition technology now to compare a live photo taken at departure with passport, visa, or immigration photos with the ones already in the government databases, and it will match it. It knows when you left. I'm sure you have started noticing that those of you have been going out of the country recently, that there's photograph. Some of them you don't have to pose as you are passing it in, takes a photograph, and it matches it with your record. Why does this matter? Of course it matters. For many years, immigrants always treated departure from the U.S. as routine. That's how we used to treat it. But that is changing. Leaving U.S. may now become immigration inspection point, where CBP can verify identity, confirm departure records, flag prior immigration violations, review outstanding issues, and potentially create records that may affect future admission to the U.S. Now, this specifically matters for people who are tourists or visitors. You have your B1/B2 visa. I'm not talking about B1 employment based. I'm talking about B1, B2 regular visa. You have your F1 students, H1B workers, employment-based visa holders, green card holders, people with prior overstays, people with criminal issues, foreign national employees who travel often. Employers also need to pay attention because this expanded tracking may affect foreign workers' travel compliance, departure records, visa renewals, and future re-entry points. See, this may not be new globally. It's new in America. But I remember how stunned I was in Dubai when I was coming back from Dubai the first time I went. I've gone several times now. But my very first time, I was stunned that you actually go through immigration the same way you go through it the way you when you came in. And if you have overstayed, they don't let you leave until you pay them their money. They will put you in jail. If you have been to Dubai before, if you overstay by 30 days, they charge you daily. Okay, for that you overstay, and you will pay that money. If you have a ticket that you have not yet paid, like a travel ticket or whatever, you are going to pay it at the point of entry, or you are not leaving. They're taking you to jail until you pay. It sounded like a joke, but I saw people being pulled out of line. Thank God me, I didn't overstay, and I did not get any ticket while I was there. So my own was, so I learned. They are bringing that kind of thing to America now. Right now, pictures get taken when you leave, whether you know it or not. They take your picture and they can match. But what they are proposing now is that you actually will then go through immigration again on your leaving, so that some of your violations can then be highlighted. Some of you will be put in removal proceedings when you are leaving the country. Yeah, that is where they are going with this. So what is my strategic Rottweiler recommendation for you? Number one, I'm going to tell you, do not assume living in America is immigration neutral anymore. It's not. It's like some other countries like this, that Dubai thing. It's not immigration neutral. They are still interested in you even when you are leaving. Before, they don't care. They only care when you come in. Now they care when you are going out. Number two, keep accurate records of every international trip, including your flight details, your passport stamps, your I-94 records, and your travel dates. Because now they may ask you to prove when you left America. They don't ask you that before. And if you don't have your passport stamp, you don't have your flight details, you don't have your travel date, you don't have your I-94 record, then you run into problem. Number three, before traveling, you need to review yourself, whether you have prior overstays, whether you have pending immigration cases, whether you have removal orders. Because if you have a pending immigration case, if you leave, if it's an application you file for, that's automatic abandonment, unless you have a travel document that they gave you, I-131. So if you have a pending immigration case, you need to talk to a lawyer to know exactly how this will be affected when you leave. If you have removal orders before, if you have criminal issues, or you have visa problems, before traveling, you need to review that and discuss with known experts. I'm talking about proper immigration lawyers. Like me now, don't go talk to Notario or some guy who says a consultant who himself probably doesn't have papers, but is advising you how to do. You're just going to get yourself in trouble. Costly $100 to book a call, or 200 if you go somewhere else. Number three advice here, or number four, foreign workers should inform their employers and the immigration lawyer for their company before any major international travel, so that they can update you. Because while you are sleeping, a new update might have dropped, and you are traveling today. You saw what happened when they changed the H-1B, that you are going to pay $10,000 if you are coming in from outside the country with the stamp. Some people were already at the airport when that rule got changed, and they had to come out of the plane. Those who are getting alert, and hopefully you have signed up for my Immigration Alert newsletter, the Rottweiler newsletter. I think I'm going to put a link. I have a link of that somewhere. Grace and Samuel, can you get me the link? You want to sign up for that, because some of those urgent updates, we broadcast it. At least you get it on your phone. Even if you're on a plane, maybe you want to come down. A lot of people, especially from India, they came down from the plane and saved themselves having to go look for $100,000 to pay, or getting the employer to pay $100,000 until that thing is resolved, or until they are clear what exactly is that rule saying. That is what I'm talking about. That is my advice. You should inform your employers and your immigration attorney, or the attorney for your company, before any major international travel. Let them reclarify. All it takes is a $100 consultation call. Oh, I'm traveling next tomorrow. Is there anything I need to know about? Yeah, of course, you can also Google, because sometimes some of these things are not out the immigration updates. Sometimes you might have come up 4 or 5 weeks before, you didn't notice it. And when you're searching now, it may not come up. So spend that money. Go talk to a lawyer. And if you already have an immigration lawyer, then call him. Number 5 advice here. And this is for green card holders. I have seen several these days who are now coming to my office, or who are going to my client and my colleague's office, who are now all of a sudden having problem being put in removal for overstaying. So green card holders, you want to be especially careful to avoid long absences that may raise abandonment concerns. In other words, you know, if you don't know, you should know that today. If you are outside the country for more than 180 days without permission, you are treated as having abandoned your green card. A lot of people don't think about this, and most times they don't hold them to it. They just ask you a few questions and then they let you in. They're not going to let you in now. Sometimes you don't even spend up to 180 days when they start questioning you about whether you have abandoned your permanent resident. They will ask you questions at the point of entry. They want to know what you are doing in Nigeria for 4 years, for 4 months. They want to know what you are doing in London for 4 months. They want to know what you are doing in India for 4 months when you're a green card holder. This is supposed to be your permanent residence. Or maybe they see that you have traveled 4 times during the year, and each time you spend like 2 months in your country. You spend like 4 months in India, or you spend 4 months in Norway, but you say you're a green card holder here, and you have done that 3 or 4 times a year. They can start asking you questions. Have you abandoned and before you know it, they cancel your green card, and now you are facing deportation. It looks to you like a joke. We have seen a big spike in that these days. So don't say nobody warned you in advance. It doesn't cost you much. When you are leaving the country as a green card holder, you want to limit how long you stay, because it is becoming a very major issue now. And of course, my final advice is, if you have any immigration complication or you think your case may be complicated, speak with an immigration lawyer before you leave the US under this new update, because you don't want any problem when you're coming back. But the bottom line here, America is building a more complete entry and exit tracking system. They are building a complete tracking system to track your entry, which we know they are doing very well and now, but the exit is catching up with them now, where there's a complete tracking system for your exit also. All these things that you think you have gotten away with here, now you can't even have a warrant on you and you want to escape, because then they check that. All the systems are linked now at the point of entry once they start implementing it, and so you better bear that before you go. They are building a complete tracking system, entry and exit. So that means immigration enforcement is no longer only about what happens when you enter the US, it's also about what happens when you are leaving. Let those who have ears, let them listen. That's the purpose of this show, to educate you, to give you a heads up, so that you are not caught unawares by a word that was declared the day Donald Trump became president. He said so, that he wants to limit immigration to America, even though he told us it was going to be criminal aliens as well as those who are illegal. But from what we are seeing here, even a lot of legal people who have been careless with their status, they are losing it. Even those who have become citizens, we never thought before that a day will ever come where people have become American citizens will be in danger of losing their citizenship. But we have seen many now. They charge them the federal court every day now, and they take their citizenship for one thing or the other. So be updated. The third update before we go to the Q&A, where I'm going to take all your questions today. Update number 3 is, again, it's all about tracking. Immigration, I like to use the word that everybody understands. I don't like using USCIS, DHS, all those ones, for those who may not understand well. Just understand that immigration, which is the USCIS now, finalizes foreign national registration. They are finalizing a rule. Okay, they have finalized it, in fact, a rule that requires certain foreign nationals who do not already have a complete immigration registration record to register online and complete biometrics. They want to know those who are here. They want to have your fingerprint on file. Now, before you start panicking, and I don't spread panic, my own is to tell you what's going down and how you can avoid being a victim. Please understand that this rule affects primarily individuals who are not already properly registered with the federal government. For instance, if you have an F1, you have a B1 visa, you have an H1, that kind of thing, you are probably registered already. You don't need to re-register. Those with complete and up-to-date immigration records generally are not required to register again. But if you are not sure, talk to your immigration lawyer to go through the list with you to be sure that you are in one of those exemptions. It's a long exemption. The rule does not apply to most immigrants. I want to be honest about that. Or people who enter the U.S. illegally. Most legal immigrants or those who enter the U.S. legally, the rule does not apply to you. This rule applies primarily to foreign nationals who are physically in the U.S. but have never been formally registered in the immigration system. In other words, you have not been in the system since you came. So who are those likely people? These are people who do not have complete immigration records, registration records. And this one will include those who entered without inspection. We call them EWI, EWI, those who entered without inspection. In other words, if you cross the border illegally and have never been registered, this rule is saying you have to register yourself so that they can take your fingerprint. Number two, some Canadian citizens, yes, Canadian citizens who entered through a land border and they were not given an I-94 or other evidence of registration before. As a Canadian citizen, you can actually generally enter through this bilateral agreement they have, and they don't give you an I-94 or evidence of registration. If you don't have that, this new rule is saying you have to register. A third category of people that I believe are also included in this registration are children who are previously registered maybe under their parents, but they turn 14 years old while in the US. They must generally re-register and be fingerprinted within 30 days of their 14th birthday. This one is important for those of us who have kids. Many of us come here with our kids when they are 9, 10, 4, 5, 6, and you know they don't take fingerprint of children at that time. But once they turn 14, they must register individually and be fingerprinted within 30 days of their 14th birthday. That's 1-4. 14th birthday, not 21st, not 18. Now, why does this matter? You are guessing it already. Failure to comply, if this rule applies to you, can create legal complications in future, even when you are fully qualified. Maybe you are married to a U.S. citizen now. Maybe you are filed asylum, or maybe you have now gotten an employment base like a B1 or B2, EB1 or EB2 visa, and then they use this rule to disqualify you because you never registered. Yes, failure to comply according to the rule will create legal complications for you in future. It may affect future immigration benefits or interaction with immigration authorities. This is why I keep saying and I keep underscoring the importance of knowing your current immigration status and ensuring that your records are accurate. As always, we're going to end with the Rottweiler's advice. My advice here, don't assume this rule does not apply to you. Before taking action or deciding to ignore it, find out whether you already have a valid immigration record. If you don't, you need to register. Acting on incorrect information could create unnecessary problems for you in future. While failing to comply when required could have serious consequences. Review your immigration history with an experienced immigration lawyer before making decisions. People will ask me, well, what if I'm illegal? Does it mean they can now come and get me? I don't know. What I'm telling you now is just explaining the law to you. At least if you know you are supposed to register and you didn't register deliberately because you're afraid, at least now you know that you are in some kind of immigration violation status. And then you behave yourself, you respect yourself. You avoid situations where you can come in contact with these people. And then you'll be prepared for the consequences in future. So you want to talk to a lawyer. If you feel that you're covered by this registration of foreign nationals, and somehow you're worried, discuss it with your lawyer. They will check the rules properly, check and help you look for what the consequences will be, maybe how to avoid to do it with and avoid putting yourself on the line of fire. But ignoring the law is never an excuse. You can't change it, it's already there. So you better figure out how to survive it. And that is what this show is all about, to point out to you what is out there. So it gives you a fair chance to try to fix whatever problem you might be having. And that is the update I want to share with you today. When we come back, we then take your Q&A for the day. And we have several of them. Some of you have posted it on YouTube. Some of you have posted it on lawyers.com for me. Some of you have posted it on Facebook. We're going to answer all of them. And if you are watching this now and you have questions for me, please post it on the chat so that we can answer your own question direct without having to come back to come and give you answer. Many of you leave the questions. Maybe you watch the recording of this show later, or maybe you missed the live event and then you came across it and you have questions. Trust me, we are curating all those questions that you leave on my site. My staff, that's their job. They check my LinkedIn, they check my Facebook, they check my YouTube for questions that people have left for me, so that when I'm doing my show, I can try to answer as many of them as possible live during the show. At least this is how you get an indirect free consultation, because with this now, you don't have to pay me any money for me to answer all these questions for you. So keep them coming, and we'll be happy to answer them when I come back. In the meantime, I have a few videos where I did a direct answer to some of your questions. Then I'm going to come back and answer the rest of them live. Enjoy.
He lost his legal status in America over one missed deadline. Not over fraud, not over crime, just one immigration date missed that he didn't take seriously. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American dreams without the nightmare. Everything was going fine for this guy. He had a valid status, steady life, no major issues. Then a deadline came up, a simple filing deadline, and he delayed it. And in the U.S. immigration, deadlines are not suggestions. They are the difference between being legal and being out of status overnight. No reminders, no grace period you can rely on. By the time he realized what had happened, his status was already gone. By the time he came to us at Banwo Law, we had to switch from planning to damage control. We explored recovery options, filed strategically, but it cost him time, stress, and money he could have avoided. So here's the truth. Most immigration problems don't start with big mistakes. They start with small delays that turn into big consequences. So if you're not 100% sure about your deadlines, your status, or your next step, you are taking a big risk you may not recover from easily. Go to speakwithope.com and book a strategy consultation session right now. Let's make sure you are not one deadline away from losing everything. Let's talk. If you're already in the U.S., you may have a legal pathway to becoming a permanent resident and not even know it. My name is Ope Banwo, and for over 29 years, I've been helping immigrants achieve their American immigration dreams without the nightmares. Every week, I meet people who think they're stuck. No papers, no options, no future. But the truth is, they just don't understand the system. Let me give you 3 powerful pathways that people often overlook. Number 1, asylum. If you have a genuine fear of persecution in your home country, you may qualify to stay and eventually get a green card here if you can document it properly with an attorney who knows what he's doing. Number 2, adjustment of status. Some people enter legally and later qualify through marriage, employment, or other categories, but they don't take action on time. Number 3, special protection programs like VAWA, U-Visa, SIJS. These are designed to protect victims and vulnerable individuals. And many people qualify, never apply because they don't even know these options exist. So listen carefully. Immigration law is not always about starting from outside. Sometimes your opportunity is already inside your situation. So before you give up or assume it's over, you may be just one strategy away from fixing your status. So go to speakwithope.com right now, book a consultation appointment, and let's review your case properly. Because in U.S. immigration, What you don't know can cost you everything. Let's talk. She married a U.S. citizen and still got denied a green card. Yes, marriage, legit marriage, but she still got denied a green card. My name is Ope Banwo, and for over 29 years, I have been helping immigrants achieve their American dreams without the nightmares. So she came to me crying. They had already filed everything themselves. No lawyer, no strategy, just forms and hope and belief in their love. What they didn't understand is this. Marriage is not the strategy to get green card. Documentation is. Timing is. Legal positioning is. So they got denied. And she was placed in removal proceedings. Now, instead of getting a green card, she was literally fighting for her life to stay in the country. Before we finally stepped in when they called us, we rebuilt the case properly, reorganized the evidence, prepared her for interview as if we are doing a legal case, not a love story. Now she's back on track, thank God. Now, listen to me carefully. Most marriage cases with immigration don't fail because the marriage is fake. They fail because the case was handled casually with a lot of assumptions. If you are filing through marriage, already filed, and you are not sure you have done it right, don't make the irreversible mistake that most people make. Go to speakwithope.com right now and book a strategy consultation with me. And let's help you handle your case like a professional legal matter, not guesswork, before your American dream turns into a nightmare. Let's talk.
Alrighty. Hope you're able to learn a few things from those short videos where we try to put in perspective some of your questions or some of the advice for you to be. I can see that it looks like Grace is already dozing over there in the studio. All right. Samuel, how are you doing today? You are still here. You are still alive here. Now, let's get to the questions of the day. You want to put up the first question that we have for me from the audience, please? What have we got?
Yeah, we have a first question here, sir.
Okay.
It said from David A. Hartford City. He says, my friend has a pending asylum case with EAD. If he gets married to a U.S. citizen, will the new immigration policy affect his green card process? That is the question from David A.
That's interesting. Put that up. Put that up. Okay. Okay. My friend has a pending asylum case with EAD. If he gets married to a U.S. citizen, will the new immigration policy affect his green card process? All right, that's a good question. We get a fairly decent amount of that even in the office. So, David, you have to understand that marriage to a U.S. citizen can still be a valid path to green card, even if someone has a pending asylum, okay, and an approved employment authorization card already. There is no general U.S. policy that blocks marriage-based adjustment simply because you have an asylum application that is pending. So your U.S. spouse may file what they call petition for alien relative, which is Form I-130, or the adjustment of status, that's Form I-485 if you're eligible. Some are eligible to file both together. Some you have to file one, get it approved before you go and attempt to get the other. However, there are some key factors that you need to take advantage of, that you need to understand that matters. Number one, the marriage must be bona fide. In other words, the marriage must be real and not for immigration benefit. They are checking that thoroughly now. They are investigating now. Number two factor you need to put on there, USCIS will review the asylum history for credibility and intent, especially if the asylum claim involve past fraud concerns or inconsistencies. So the fact that he had asylum before will not stop him from applying for green card through you, But now they can still look at that old asylum and see whether it was a fraudulently put together one or there are inconsistencies there between what he said in that asylum and what he's saying now when you guys go for interview. So it's important for him to have a copy of that so that he remembers what he puts in the asylum application. That's what I said in my opening advice of the day. Have your immigration file. Everything you file with immigration, get a copy. Another factor that you should consider is that the asylum case may remain pending or be administratively closed, depending on strategy. Okay, you might decide to close the asylum, or you might decide to leave it pending the determination of your marriage-based petition, because not all marriage-based petitions that are getting approved right now. So everything depends on how good your petition now looks versus going to abandon your asylum before you file. All of that requires strategy, and you need to talk to a lawyer before deciding what to do about that. But importantly, know this: a pending asylum case does not automatically harm a marriage-based case, but both cases must be consistent and truthful. So your friend should be careful not to make conflicting statements between the asylum and the marriage filings. It's another reason you must get copy of the old file. You must get copy of whatever it is you file. Because if whatever you are saying now under marriage is inconsistent with what you had said during asylum, you can end up losing both. And that is why you talk to lawyers before you take any step. All right, I hope that helps you out. I like to give complete answers, not like those lawyers who give you up and say, come and call me. That's a full answer to your question, and I hope it helps you. All right, what have we got next, Stephen?
Yes, we have this from Tricia in Brooklyn, New York. It says, my husband's I-130 was denied after he missed an interview notice he never received. We reopened the case with Form I-230B. Is approval now guaranteed?
You mean, okay, go on. Okay, go on.
So he's asking if is approval now guaranteed?
Let's put up the question to be sure I had it. Okay, it's 290. You are saying 230B. I'm like, what are you talking about? All right. So he's saying that my husband's I-130 was denied after he missed an interview notice he never received. We reopen the case with I-290B. Okay. Now the question is approval now guaranteed. Tricia, unfortunately, no immigration cases approval is ever guaranteed, even after you have successfully reopened it. All you have done with your I-290B is to reopen the case. It doesn't guarantee that they're going to approve it. The good news, however, is that immigration has agreed to reopen the case. For some, they don't agree to reopen, which suggests it found some enough reason to take another look at the case. That's very good news. Now, if the denial was based primarily on your husband's failure to appear for an interview that he was never properly notified about, as you have said, then reopening gives you an opportunity to address that issue. However, immigration will still review the underlying I-130 interview, the I-130 petition for alien relative, that form that you filed that was reopened. They are still going to review it, and they will determine whether you have established a bona fide marriage and met all requirements or not. So you must make sure you respond promptly to all notices that they give you. Keep your addresses updated. I've seen too many cases denied or get into problem because addresses were not consistent, or they change address and they did not properly notify immigration, and they get into more serious problems than they bargained for. You must gather strong evidence of your ongoing marital relationship. This is important. Some people just assume because they are married, because they are living in the same house, because they love themselves, or even because they have children. I've seen an I-130 case, several, denied, even though the wife has had a child during that marriage. Having a child is not what proves that your intention was not to marry for fraud. you have to have documentary evidence that your marriage is real. We have had, because they are not stupid, they know that some Americans who are already pregnant by somebody else, okay, they marry somebody for papers and then they say, oh, you had a child for me. Sometimes they order DNA now. Okay, and so just having a child is not guaranteed that they're going to approve your stuff. So you must gather strong evidence of your ongoing marital relationship. And of course, you must attend future interviews as instructed. There is nothing like automatic approval. So reopening a case is a positive development. I have to tell you, it's not everybody that are lucky to get that. But approval of the petition itself would depend on the total evidence and the facts that you present to immigration when they reconsider the petition. That's all reopening means. It simply says we are willing to reconsider our position on this case. It does not mean they've now agreed with you that you deserve to get it. So you still have to be prepared. Get your lawyer. Prepare properly, because there are no guarantees. But congratulations anyway, at least they reopen it. That means you live to fight another day. All right? Hopefully that helps you. All right, Stephen, what else have we got?
All right, we have from Ahmed in New York City. He's saying, my B1, B2 visa was refused in 2009, sorry. On the DS 2060, should I answer yes or no to the question asking if I've ever been refused a US visa?
Okay, can you read again? Do you have the question typed? Can you put it up?
All right, sir.
Okay, so he said his visa was refused in 2009. Okay, then he wants to know, now he's reapplying, I guess, on the DS-260, the application form. Should he answer yes or no to the question asking if ever been refused? I mean, isn't that obvious? The correct answer is yes. It doesn't matter that it was 17 years ago. Even if it is 100 years ago, you still got to answer yes. They did refuse it, because now all the systems are linked. Don't kid yourself and say they keep record for only 10 years. That's a lie that people are finding out to their chagrin. Okay? Mr. Elon Musk has merged all these things. So we know what was done before. The DS-260 is asking you whether you have ever been refused a visa, refused admission, or withdrawn an application for admission at the entry. That's what that question always asks. It applies to all US visa refusals, not just immigrant visa refusal, not just apply for green card, they didn't approve that, or apply for asylum. No, all green card refusals. So you must answer yes, because it was refused in 2009. Of course, during the interview, you are going to have an opportunity to present or provide the details about the refusal. Don't worry, they're going to ask you about it, and then you're going to explain to them what happened, and that's fine. Having a previous refusal does not bar you from applying for a new one, so there's no need to lie about it. Answering truthfully is very important, because consular officers, they have access to prior visa records, and failing to disclose a prior refusal could create credibility concerns. In fact, it will create credibility concerns for you, or be viewed as a misrepresentation, which is even worse. Or they charge you for immigration fraud and you are banned forever. Or because instead of answering yes, you answered no to a simple question. A prior visa refusal does not automatically prevent them from approving a new one for you, or from approving an immigrant visa, even a visitor visa. It doesn't prevent it. What matters is providing accurate information and then meeting the eligibility requirements for the visa that you are currently seeking. I've had clients who have been denied 5 times, and on their 6th time, they were given. I've had a client denied an L1 before, and we reapplied for the same client within 3 months, and that same application was approved. And in the new application, we told them, yes, an L1 was denied before. That was filed by a different lawyer. And they came to me and they were like, what else can we do? Is there any other visa options for us? And I'm like, no, I'm an L1 specialist. Let me look at what they filed for you. And then I reviewed the whole thing. And I felt that, not that the other lawyer even did badly. I'm not going to run down any other lawyer. But there are some, the presentation was a little bit off. And I felt that I could do a better presentation. I could write a better brief to justify that managerial status for that person. So I said, let's file another one. And the person was nervous. I said, no, we are going to tell them we have applied before, but we are reapplying now because we feel that the previous one was not properly done. And they did premium processing. He got his approval in 28 days. So you don't have to lie. Just be ready to respond. Why was it denied? The issue that they raised when they denied for you the first time, you must understand it. If possible, seek a legal opinion about how to answer it properly. And so that when you get in there and they raise it, you are not stammering. Okay? You answer, and based on that, they are not going to disbar you based on previous denials. They are going to look at your applications now. And I can't tell you how many times I have filed the same application for the same person that have been denied before, especially if they filed it by themselves. I've had a big success with that. Because most times people can collect the form on the immigration side, they can read the instructions and they can file. Sometimes they get lucky, it gets approved, but maybe they miss some critical things. And sometimes some of those questions are counterintuitive because they answer it in a double negative. They ask it in a double negative. So if you are not clear, you go and put yes, even though it's no, you are supposed to put, and you are not trying to lie. You are not trying to misrepresent, but the way you understand the question was wrong. I've had a client argue that with me right inside my office here. They filled out their form, they sent it to me. They put no where they're supposed to put yes. And then I changed it. When I gave it to them to sign, they were telling me I made a mistake. I said, no, I didn't make a mistake. This is what you told me. This is what your file said. This question is a yes answer. And the person was arguing English with me. I'm like, well, if you want a no, I'll put a no for you, but you're going to have to sign a waiver for me that I told you, just in case there's a problem tomorrow. And he said, okay, you are the lawyer, you do what you have to do. And luckily, it got approved. So sometimes it's not because you even want to lie. Sometimes the questions can be confusing, even to me, to us lawyers. Sometimes we have to double check again, especially when they change forms. And they're always changing them. They change forms regularly now. Every 6 months or 1 year, they will have another form that has a different year. They've added 1 or 2 questions, and if you're not careful. So a refusal, just to come back to your question without derailing so much, a refusal is a refusal. The answer is a yes. It doesn't stop you from getting what is due to you if your application is solid enough. All right, I hope you get that. That's a long answer. I like to give very long answers, so that you don't have to do any consultation to at least answer that. Okay? I don't do bait and switch here. Full answers. All right, Mr. Stephen, what else do we got?
Yeah, Samuel, we have from Michael here. It says, what legal options are available for a highly educated Christian living in Iran to immigrate to the United States?
Whoa, we'll say again. And
Yeah,
please put it
from
up on the
Michael.
board. You have it, put it on the board. All right,
All
please say
right.
it again.
Yeah, it's from Michael. He said, what legal options are available for a highly educated Christian living in Iran to immigrate to the United States?
Wow, Iran. At this game, Iran, long, with what they are dragging with us here. Okay. Well, the truth of the matter is that whether there is a war going on or not going on, they have not essentially cancelled all visas for Iranians. So that might be good news. So there are several legal pathways that may still be available for people from Iran, despite the war that is going on, because it depends on your background and your circumstances. For instance, employment-based immigration may be an option if the person has advanced education, specialized skill, extraordinary ability, or a U.S. employer willing to sponsor them. That is still available for Iranians. In other words, EB1, EB2, EB3, all of those are still available. H1B, O1, all those employment-based options are still available for Iranians if they have employers willing to sponsor them. Student visas also can sometimes lead to employment opportunities and later immigration benefits. There's also family-based immigration that has not been cancelled. It may be available if the person has qualifying U.S. citizen or lawful permanent relatives who can file for them like everybody else. There's also asylum, which is very strong for them now, because if you are not part of those who believe in that regime, or if you are part of those who are being persecuted for being a Christian, it does not automatically qualify you, but you have to then make your case like everybody else. If you have suffered past persecution, or you have a well-founded fear of persecution because of your religion, you may have a potential asylum claim. Eligibility depends on specific facts and supporting evidence. It does not necessarily mean, oh, I'm in Iran, they have mullahs there who are killing everybody, so come and give me asylum because I'm a Christian. No. You still have to meet the conditions for asylum. In other words, you must have suffered a welfare of persecution because you're a Christian. Okay. You must also be able to show that you can't live in another part of the country if they were to send you back. So there are several requirements to get asylum. And once you can establish that, yes, whether you're Iranian or not, they will give you. Other possibilities may also include investor visa. If you have money, okay, America will always take your money and give you a green card. There's the EB5 there. There's other investment opportunities. A religious worker, or humanitarian programs, depending on your qualifications. So I would recommend that you will need an immigration attorney to help you break it down, okay? Because the immigration lawyer will need to evaluate factors such as education, your work experience, your family ties, your immigration history, your financial resources, your religious circumstances, and your long-term goals before identifying the best option for you. Is what I do. That's why when you come to my 1 hour consultation with you, we'll explore all of that. And by the time you are leaving that 1 hour consultation, at least you have some ideas of the opportunities that are available to you, whether you're from Iran or from Nigeria or from Ghana or from South Africa. It does not matter, because immigration pathways are highly fact-specific. So a detailed consultation is essential before you pursue any strategy, regardless of what country you are from, especially if you are from Iran. It's not something that just answer in a vacuum. And by the way, like I always put a disclaimer every time I go on live. Where is that my disclaimer? Okay, you have to understand that the content of this show is for educational and informational purposes only, and does not constitute legal advice. I can't give you legal advice unless you are my client. Every immigration case is specific. I want you guys to know that. Don't say, Dr. Clay said this on his show, therefore it applies to me. For specific advice on your situation, you need to book a special call. You need to talk to an immigration lawyer, or book a call with me at banwolaw.net/consultation. banwolaw.net/consultation, or speakwithope.com, whichever is easy for you to remember. Speakwithope.com. You book a call there, and then we go one-on-one on Zoom. If you can't come into my office, then we can meet on Zoom. Then I can give you advice that is specific to your own specific situation. I have a call coming in here. Hello.
Hello, sir.
Hello. Who's this?
Yeah, hello, sir. Janelle, your loan financer.
Okay, sorry, I'm live now. I thought you were an immigration client calling in. I'll call you back when I'm out of the show. We are in a live call right now. Okay.
Yes, sir. Okay.
All right.
Okay.
Sorry about that. That's my banker. Okay, so book a call to clarify where you stand as far as your immigration status is concerned, whether you are from Iran, you are from Ghana, from Rwanda, wherever you are from. It's only $100, banwolaw.net/consultation, and let's clarify it for you. All right. Do you have any other question that is posted on my Facebook or anywhere else? Mr.
Yes, I have a question here.
Okay.
It's from Jason. It says, I filed a FOIA request after my green card interview. Could that delay my pending I-130 and I-485 application?
He said he did what?
Yes. He said I filed a FOIA request after my green card interview. Could that delay my pending I-130 and I-485 application? That's from Jason in Atlanta, question 5. Yeah.
All right. Thank you for putting that up, Grace. So, yeah. Generally, I will tell you, Jason, that no, that is not going to delay your pending I-130 because you requested for a copy of your file, which is the FOIA is called Freedom of Information Act. It's something you do under what we call Freedom of Information Act, FOIA. A FOIA request does not automatically delay your case or delay your I-130 or I-485. No. Immigration typically will process the FOIA request through a separate office from the officers who are deciding your immigration benefits. So there are two separate offices that deal with this. The one that deal with your case that is pending is very different from the one that will process your Freedom of Information request. So as a result of that, your FOIA request is not intended to pause or interfere with the decision-making process on your applications. They are separate things. It's like calling the reception to ask for your the status of your case, and then somebody is working on it separately at the back. But that said, some applicants believe delays can occur if records must be retrieved or reviewed, but there is no U.S. policy stating that the properly filed FOIA request will delay your I-130 or I-485. I can understand when they have to carry the file physically, just using the analogy of you have a file in our office, a lawyer is working on it in the back office, then you call the reception, you want to know the status of your case, or you want copy from your file. Now the reception has to go get the file and then make a photocopy. While he's making those copies, of course, the lawyer who's working on it will not be able to use your file. But that's not the case anymore. All your file is probably, immediately they receive it, they actually scan it into their system. So it's electronic. So the person that is going to do the FOIA just need to access it, download what they need to download. The person that is working on the file, they just need to click a button to keep working on his file. So I don't believe your FOIA would delay, and there is no immigration policy that says so, because if it does, immigration will have issued it as a notice so that we as lawyers and you as members of the public will know that when you do a FOIA, this is going to delay your case, but there's nothing like that. So since you have already completed your interview, according to what you just said, okay, I don't think this is going to affect you, that you are asking for a FOIA. So since you've done your interview, your case may still be undergoing background checks. It may still be it may be pending supervisory review or a final adjudication, or maybe they're even doing investigation as we speak. Those are more common reasons for post-interview delays, because they want to check some things. They want to check some of your story. They want to check some of your documents. Okay, not because you apply for FOIA. So I will advise you to continue monitoring your online account and case status. If your case has exceeded normal processing times, then you may submit an inquiry. And this is where a lot of our lawyers are not doing a good job for their clients now. There are 3 ways you can go about, especially for this kind of case where you have done interview. And we have been having some great success with that recently. You can then follow up. Let's say the normal adjudication time is 6 months, and your own is now 11 months or over a year, is what I'm saying. You can't start stressing them. If they say it's 18 months, they're going to process, and you're in the 12 months, there's really nothing you can do. Okay, you have to wait until the process, estimated time that they themselves indicated on their website is over. But let's say it's over. They say it's going to take 6 months. Now you are now at 16 months. Now you can do a request. You can do it in 3 ways if you want to get a solid answers and positive. Of course, that's what they call the service request. One of that you can do online on their website. You just fill out some questions, and then they might respond to you. An elevated level of that is that your lawyer will then file. I have several here that I've just done. I got one approved in under 2 weeks when I did it. I just have several on my table now that I'm going to be made. Your lawyer can also send a package. It's called a service request package that will include a cover letter from the lawyer, will include a statement of hardship from you, that the hardship you are going to suffer if they don't get your papers approved. Maybe your work permit is pending and they've not yet approved it. That hardship, you are going to lose your house, your medical that you are paying, all that stuff. You gather the records of what you do with your money. And your lawyer can put all of that together to request for them to act on it expeditiously. That is a second level from just going to online and filling out a form. A third level you can do is what is called the Immigration Ombudsman. A lot of people, even lawyers, are not aware of that. Immigration has something that is called the Immigration Ombudsman. This is a statutory body now that has been put between immigration and the public. Their own job is to follow up on your cases with immigration. It's an amazing service. Now, of course, they have requirements for you to qualify for the ombudsman to come in. You must have made a request about your case before immigration, and you have a receipt, like that online one that you have already made a request. They did not grant your stuff yet. You have that proof and a few other requirements. The ombudsman's office, their job in life is to go meet with immigration and find out what is happening with your case, and they're very effective. Okay, you will see them if you just type Immigration Ombudsman. Their website will come on, and you can actually complete the application online, and they will ask you to submit several documents. I always advise you to do it with a lawyer, because even though you can do it yourself, they're going to ask for documents and all of that, and then the reason and what the prejudice you're going to suffer, all that stuff that they need to use to defend, to use to talk to immigration on your behalf. They don't charge. It's 100% free. So if you have a lawyer who's helping you, your lawyer will just help you go there and make that ombudsman application. But you can also make it yourself. A lot of people are having success just doing it by themselves. That is step 3 you can take to follow up on your pending case. Step 4 is the congressional support. Literally all congressmen in America, they have a department that is dedicated to helping immigrants interact with immigration. They are also very good. They will call you back. They will follow up with you. They are doing that with all my cases now. And it's amazing. So when you contact first you have to determine who is the congressman in charge of your area. They are not like this in Africa. That's their job, to help their constituents. So you have to know the congressman that is in charge of your street. And it's easy to find. Just go and search congressman in charge of this address. Put your address there. Google will tell you, it will give you the name of the congressman that is in charge of your neighborhood. Then you go to their website. All of them have website. Every one of them. You click, you go to their website. On the website, they have a button that says, depending on the website, but generally they have assistance with government agencies. There's a button on their website that will say assistance with government agencies. When you click that button, it will then ask you what kind of assistance do you need. Is it immigration? Is it welfare? Is it whatever? Then you click on immigration, and then it will tell you what to do. You fill out a set of questions. You submit some documentation about your case to show that you have gone to ask them. They haven't made a decision that you're going to lose your house, that this will happen to you if you don't get your papers approved, blah, blah, blah. And they follow up 100% of the time. Every time I've done it, the congressman's office have sent us an email asking my client to sign a release form, giving them permission to go and follow up with immigration. And a week later, they call us to tell us what they have done and to see whether we have gotten any response. Very powerful. So those 4 ways, Jason, that you can follow up your pending interview apart from the FOIA. I mean, I'm talking now for those who have had, even though that's not your direct question, I'm talking about those whose cases have been pending for a long time. or maybe you have gone for interview. 1 month has passed, they've not given you a decision, 6 months have passed. Those are very, very ripe cases for the ombudsman, for the congressional support, for your lawyer to make a formal case inquiry, and for you to also do an inquiry online. My recommendation again is don't try to do these things yourself. They don't charge too much. I don't charge a lot. Go book a consultation if you want to talk to me about it, if you have a case that has been pending, especially if it has been pending for a long time. I've had people who have done interview 6 months, they've not gotten a decision. Those are the ones that are ripe. The ombudsman likes those cases. The congressman likes those cases. So for follow-up with immigration, I just wanted to put that little tutorial there about how anybody who has a case pending with immigration for a while can actually go there and follow up properly, not just praying and fasting, and not just calling that 800 number they have. There are other organizations now that can put pressure on them legally. The ombudsman is number one. Your congressman, that's why he's there. They have a job. The congressman is to follow up with the government agencies to find out why are they screwing up with your case. Use them. They don't charge you. And they are happy to follow up with you because they want, when you become a citizen tomorrow, they want you to vote for them now. So they start to cultivate you now. It's not like the politicians in Africa. They don't bribe here for people to vote for you. People will vote for you based on how effective they think you are. So the congressmen know that. So they start servicing you now before you even become a citizen. All right, that's a long answer, but I like to give very long answers to make sure that you are fully educated. But to come all the way back to your question, because I like to digress a lot, your FOIA will not affect your pending application. They are two separate things. They are run by different people. If you're having fun on this show and you're watching this now, I want you to put in great into the chat for me or say something nice. Encourage us. Great job or something. All right, if you're watching this and we are live on Facebook, I think we are live on Instagram. If you're watching us on Instagram, please put something there for me to be sure you can see and you can hear me. Just put great show. I love you, Dr. Ope. Even if you don't love me that much, just put that one in there. At least make me smile small. I think we are live on LinkedIn. If you are watching this on LinkedIn, please make a comment or put your questions on there so that we can answer. Your questions are supposed to come into the studio right here. We are using a digital studio right now to do this. When you put your question wherever you have it, it's supposed to show up in my studio. All right. Well, thank you so much. Let's bring Grace up. I know Grace also has some questions for me here. Grace, do you have any questions or do we continue with Mr. Samuel? Do you have any questions tonight? I thought you were sleeping off that time. I didn't want to show you to the whole world.
I have. Yes, sir.
Have some questions.
I have. Yes, sir.
What do you have?
Right. Let me go. This one is from Robert.
Okay.
It says, I am a green card holder with no criminal history. Is it safe to travel overseas for about 3 weeks to visit family and return to the US? Robert from Atlanta.
Okay, I like that. Please see if you can put up the question for me. Because it's good to always ask these questions, because if you don't ask and then you get stuck, then you can't be crying thereafter. All right, thank you, Grace. Is it safe for you to travel for 3 weeks to visit your family and return to the US? People, don't laugh at Robert. It's a very legitimate question to be asking in this day of where things could have changed overnight. So, Robert, generally, yes, it's very okay for you to travel for 3 weeks. A legal permanent resident, that's somebody with a green card, okay, may travel abroad temporarily. That's according to the rules, and return to the US. A trip of approximately 3 weeks is typically considered a short absence, and by itself should not affect your green card status or your ability to come back to the US after you have gone. Or no, that's just 3 weeks. They don't typically hold that against you. Because as always, though, admission is determined. I want to be clear. So don't go and say, I say automatically they will let you in. As always, admission is determined by the Customs and Border Protection Agency at the point of entry. So that's why the fact that it's a short exit that should not typically cause a problem. Okay, CBP will see determine that at the point of entry. So before traveling, make sure your green card is valid and unexpired. I put that first as my recommendation because I've seen that happen. Somebody traveled for only 18 days, which is even less than 3 weeks, but he did not check his green card. His green card expired while he expired 9 days after he left the country. So he didn't check the expiration date of his green card before he left. And when he was coming back, they told him his green card has expired. He has to go back and try to get it back by applying for extension, by whatever. Long story. I didn't represent the client, but I had the story when he called me, but he wasn't ready to pay what it is because he felt that he's a green card holder. It's a small problem. He can get it done. And he was calling me, I think, from Sierra Leone or somewhere, or Cote d'Ivoire. I don't know. So I always advise my clients now, your green card, make sure you check that it is valid and unexpired. Make sure your passport is valid for travel for more than 6 months. I've seen people who have been turned back because their passport expires in less than 6 months, especially if when you are leaving the country you are coming from. You maintain your primary residence in the US. Make sure that when you travel with somebody who has a green card, that means you are saying you are living here permanently. So you must have a primary residence in the US. You must have an address where you live in the US. Because if they ask you where do you live, you say, oh, your rent expired, you're going to be getting a new house or whatever, you may be denied right there. That means you don't have a permanent residence. You must have a primary residence in the US. Very important. I don't care if you have a green card, especially if you have a green card. Your green card says I live permanently in the US. So if you don't have an address that is clear, that they can check, that shows your name, that you live there, you may have a problem. But short trips generally do not affect your coming back into the country, and it doesn't even affect your naturalization eligibility, although they can deduct the times you are outside the country from the time you are here to calculate your 5 years. So while immigration policies can change, there is no current general rule that I know. I like to say that because maybe when I'm sleeping this night, yesterday night, maybe they changed the rule that I have not yet seen. But there's currently no general rule that I'm aware of that prevents green card holders from taking brief trips internationally for family visits. You're allowed to go. It's called permanent residence. Okay, it doesn't mean that permanent stay here. You can go, but just make sure you take those precautions that I just mentioned. Check your green card, check your passport. Make sure you have a primary place of residence. When you're filling that form, when they ask you to fill a form, by the way, and they say your primary place of residence, don't go and fill a foreign address. That's like that's our own goal right there. Okay, your primary address is supposed to be America if you have a green card. Don't go and put your father's compound. You know, in Nigeria, they will ask you your permanent home address, and all of us will put our mother's village that we have never even been for a long time. You put it as a permanent address. Don't do that here. Okay, when they say your primary place of residence, it doesn't matter if it's a one room you are using in America and you own a mansion in Nigeria in your village. Your primary residence is that one room that you are using here. Your mansion in Ghana is a temporary accommodation, at least for immigration benefits. I hope that is clear. All right, let's go. Mary, or Grace, rather. I don't know why I keep calling you Mary. Maybe Mary has to be your middle name. Mary Grace. All right.
Okay, sir.
Let's hear from Samuel for a second. Samuel, do you have any more? Samuel. I think Samuel has dozed off. Or is he still there? Oh, yeah, Grace, do you have any questions? Or are we done?
All right.
Yes,
so
we have another one from David.
Okay. Okay, let's hear David's question.
Okay. It says, for my N400, How can I prove? Okay. For my N400, how can I prove that my children live with me and that my spouse and I financially support them? David from JC City.
All right. Again, when you finish your question, please let me try to put it up so that those who are listening can also, we can also, because sometimes hearing you very well can be a problem. Okay, thank you. For my N400, how can I prove that my children live with me and that my spouse and I financially support them? That's an interesting question, David. Yes, immigration may ask for evidence showing both financial and resident support for your children as part of their check to be sure that you are legit and you are ready to get your citizenship. The documents that can help you prove your children live with you include school records showing your home address, which is why where you live, you want to make sure that the school records of your children reflect that address. Medical or insurance records, because if your children live with you or you support your children, they will be going to medical every once in a while, and they have insurance. It's not like Africa where children may not go do medical insurance for 15 years. I don't know the last time Grace went and did. When did you go for medical checkup last, Grace? Eh? When you were young, when was the last time they
I
took
have
you for
not been,
medical?
sir. No, yes, sir.
They give you agbo to drink. That's what they used to give me that time.
That one should be in primary school, sir.
Now, which one is medical record? They give you agbo to drink. All right, but medical insurance records is proof. Lease agreements, listing household members. There are some agreements or mortgages that require you to list household members. If you have that, you can show that. You can also show government or official correspondence that was sent to the same address. The one that was sent to you, the one that is sent to your children, the one that is sent to your spouse. As long as it's the same address with the different names, that's also a way to prove that your children live with you. As for the financial part, obviously the most available one is federal tax returns, claiming your children as dependents. Because if you are taking care of your children and the children are living with you, you are more than likely going to claim them on your tax because they give you some money back, or they give you what they call a child allowance on your taxes in America. So you will have claimed them and it will show there. You can show bank records showing payments for their expenses. Maybe they went for daycare, or they had to buy something in school and you paid for it. Those records also prove that you take care of them. Health insurance record, obviously. School tuition and childcare payment records, the records of payments you make for the school, and then a major child-related expenses. Every child, talking from experience, they always have one expense or the other. All right, so the records of paying those expenses and the receipts is a part of what you can show to prove that your children, you are taking care of them and they live with you. In many cases, tax returns are some of the strongest pieces of evidence because they demonstrate your household composition and financial support. Remember, in your taxes, they're going to ask you, are you married? How many children? Do you have anybody staying with you? So it gives a better picture of how many people are in your house. Immigration does not require a single specific document for this kind of thing. So the goal is for you to provide credible evidence that is showing that your children, that they reside with you, and that you contribute to their care and support. As I always advise my clients, you want to over-document that. If it is 10 documents you can send it. Don't just send one. And they are not requiring any specific one. So with immigration these days, because they are skeptical of everything, they don't trust anything. So the more you are able to give them, the more your chances of avoiding any complications later. I hope that answers your questions. For those of you who are just joining us, you are watching the Immigrant Survivor Show with Ope Banwo and his team. And we are what we call the America's no-nonsense immigration survivor show, where we talk about real immigration news, real legal answers, We are real immigrants. We help them to navigate the American dreams so that it doesn't become a nightmare for them. And we appreciate you for joining us today. Hopefully, you have been able to learn one or two things. I'd like to give a very comprehensive answer to every question. That way, it's almost a tutorial too, so that everybody can learn without having to seek a consultation if that's the only question you really have. But I do advise you, okay, whatever you do in America today, try to talk to an immigration lawyer before you do it. A simple consultation of $100 or $200 can save you thousands of dollars down the road. Of course, I represent clients all over the country. So if you want to talk to me, where's my link here? I'll be more than happy to talk to you. If you want to consult with me, whether you're outside the country or you're anywhere in America and you need a consultation, we do virtual consultation on Zoom, one-on-one video call, where we can talk and look at all your documentation and give you solid advice for 1 hour. Or if you can come into our office right here in Arlington, Texas, or our other office in Omaha, Nebraska, wherever you're joining, you can walk in to the door and get a consultation done. It's only $100 for an hour of consultation, at least for us. I think our Omaha office charges $250 now, but that is okay. A lot of lawyers charge that and even more for consultation. All right, but either way, don't be penny wise, pound foolish. Talk to professionals before you put anything with immigration. If you have been served papers, a notice to appear, don't just sit on it. Don't just think I can handle it. That's a serious legal issue you just have. Go find a lawyer. If you have applications filed and you got a request for evidence, that's not something you should be handling yourself. I've seen a lot of good cases denied because people try to answer the RFE themselves. Because RFE has become legal. In part of the response, you have to cite legal cases why they must approve your case, not just answer the questions that they give you. So there are some things you get from immigration that you absolutely should get a lawyer. Even though many of the immigration things you can do yourself. If you are smart and intelligent, they have the rules on their website, they have the forms on their website. All you need to go there is download the forms, read very well the instructions, and answer properly. You should be okay. Even though I think you'll be stupid not using a lawyer, but some people are not stupid, they just don't have the money. And if you don't have the money, you got to do what you got to do. All right? What else have we got? Let's take one more question, then we have to take a break. And then maybe when we come back, we'll close the show. We're already on this now, almost 2 hours now. It's supposed to be a 2-hour show. We have 8 more minutes to go. So let's take the last question. I'll take that from Samuel. What have we got?
Yeah, we have a question here from Michael. He's saying, my EB2 national interest waiver priority date is current. Are there any disadvantages or risks to filing the I-140 and I-485 together?
That is a very, very good question because a lot of confusion among please let me put the question up. It's important. I really want this up for many of those who are applying. Thank you. For many of those who are applying or who are thinking of applying for EB2 or EB1 and all that. Okay. If your priority date is current, it's asking, are there any disadvantages or risk for applying for both together? Because typically for EB2 or even EB1 or any of the EBs, you can file the I-140 first. When that is approved, then you go and apply for the green card, which is the I-485. But sometimes your I-140 may take a year, may take 9 months, it may take 15 months before they approve it. Then you then file for the green card later, which will then extend the time you're going to get your green card by years. But some immigrants are allowed to file both together, especially they are here in the country. The immigrant for alien worker, the I-140, the EB2 thing, and the I-485 for green card. So it is generally permitted and it is commonly used. If your status is current and you are eligible to adjust status, concurrent filing of both the I-140 and the I-485 is generally permitted and it is commonly used by those who are savvy. There is no immigration rule stating that the concurrent filing automatically results in longer processing times. In fact, many applicants choose concurrent filing because it allows them, very important, to also apply early for their work permit and advance parole. Because the I-140 does not allow you to apply for work permit, does not allow you to apply for advance parole, but if you file it concurrently with the application for green card, the I-485, now you can get work permit immediately, and you can also apply for advance parole immediately. Advance parole is what allows you to travel outside the country while your case is still pending. So, to me, it is generally a good advice for you to do that. But of course, the potential disadvantage include, for instance, if your I-140 is denied, then your I-485 will be denied as well, generally. They're going to deny both together. They're not going to deny your I-140 and approve your I-485. Both of them go down, okay? Another disadvantage is that filing fees are incurred upfront for multiple applications. In other words, you will have to pay for the I-140 and also pay for the I-485, both of them together. So if they deny, let's say for instance you don't qualify for the I-140 and they deny, then you lose the money you have submitted, you have paid for the I-485, and they're not cheap. So that might be one of the disadvantages that you may want to consider. I've seen somebody tell me, I don't have the money for the green card application now. Let me file the I-140 first, and then when that is approved, hopefully I'll get money to file the I-485. Or if you are not sure that your I-140 is solid, that it's going to be approved, you may want to save yourself some money by not putting in the I-485 yet until the I-140 is approved, so that you don't lose that money. That's really the only drawback I can see. Okay, so the main advantage of filing both together is efficiency, especially when visa numbers are available, because that thing regresses. If they are current, you want to hit it right now, apply for your green card with your I-140, because they go back. Sometimes in another 6 months, they can say now it's 2-year waiting period, meaning that after you got approved, now you have to wait 2 years. So if your EB2 priority date is current now, definitely I think the advantages outweigh the disadvantages. It's just money that you might be risking by doing both together in case you are not approved. So before you file, of course, you must ensure that your priority dates remain current under the applicable visa bulletin, because normally the bulletin changes every month. Every month they bring out a new bulletin. So it may be current this month and then not current next month. So your lawyer or yourself, you must check the current visa bulletin before you file. But if your status are current, I see no reason why you should not apply for both together if you can afford the filing fees. Why? Because the advantages are so much more than doing it individually, especially getting the work permit, which is what all of us are looking for. Work permit allows you to work legally, it allows you to do a lot of stuff. Also, getting an advance parole allows you to not be stuck in the country if your case is taking 12 months, 15 months, so that you can travel outside the country and come back while your case is pending. Because if you travel without advance parole, your case is automatically abandoned. And you can't get advance parole if you do only I-140. So to me, it's a no-brainer. I tell all my clients, if they have a current EB2 priority date, they should file both together. All it's costing them is that extra filing fees. I hope I'm able to answer your question thoroughly tonight, hopefully. And if not, join us for our next episode next week, Monday. But before we go, I'm just going to play a couple of my pre-created answers for some of your own questions here. Then when we come back, we will close the show. Thank you for having us tonight. We enjoy you. We enjoy being on the show with you tonight. Same thing, Mr. Samuel. Thank you so much for being here. And Grace, Mary Grace, thank you for being here. We will say Daddy has given me a new name tonight. All right?
Thank you.
We'll be right back.
If you own a business outside the US, you may already qualify to move to America legally with your family. The problem is, nobody tells business owners this. Instead, they push you toward student visas or visiting visas or H-1B visas when there is a much smarter path designed specifically for you as a business owner. Let me break it down for you simply. Number one, there is the L1 visa. If you have a company in your home country, you can open a branch of it in the US and transfer yourself as an executive or manager to the US office with your family. Yes, you can literally expand your business into America and move in with your family with authority to work and permanent residency. Number two, the E2 treaty visa. Now, this depends on your country. But if eligible, you can invest in a US business and live here legally while running it. And here is what most people don't realize. You don't always need millions to start. Listen carefully. America is not closed. It has only become more selective. If you understand how to position your business properly, you can enter legally without begging for sponsorship. So if you're a business owner, still thinking like an employee, you are limiting your own opportunities to achieve your American immigration dream. Go to speakwithope.com right now, book a consultation, and let's map out the smartest entry strategy for you. Because the fastest way into America is not through a job. It is through leverage. Let's talk. My name is Ope Banwo, and they call me the Immigration Rottweiler. Not because I bark, not because I make noise, but because I don't let go. When your case gets tough, when the system pushes back, when others start telling you there is nothing we can do, that's when you call me. Because once I lock into your case, I don't stop, I don't quit, and I don't back down until we get results. So go book a consultation on speakwithope.com now, and let's activate the Rottweiler mode on your case before the immigration knocks on your door. Okay, that's it for tonight, people. Thank you so much for being part of the show tonight. Please send in your questions to any of our platforms where we are all over the social media. We have an account on LinkedIn. We are live there right now. We have an account on Facebook. We are live there, right there now. We have an account on Instagram. And I believe we have an account also on TikTok. We are not live on TikTok right now because our studio cannot broadcast to TikTok yet. But we'll be doing a live show on TikTok soon too. All right? Just be safe. Check your immigration status. Get an immigration lawyer. Make sure your interests are protected. You don't want to start dealing with crisis. You want to solve your problem before it becomes a problem. That's it for tonight. Thank you so much, Samuel. Thank you, Grace. I look forward to see you guys in the studio right after this. Guys, back at home.
Thank you.
We'll see you on our next show coming up next week, Monday at 2 p.m. Eastern Time. Good night.
Right. Thank you, sir.